All rise. First District Court of Appeal is now in session. All who have business before this court, draw near, give attention, and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. Good afternoon. We have 3 cases on the docket this afternoon. We are not taking them in the order they appear on the calendar. We are first taking the case University of Florida Board of Trustees versus Rojas. After this argument, we will break for coffee and reconstitute the panel. So counsel, in the first case, if you are ready, you may proceed.
Good afternoon. May it please the court. My name is Rob Sniffen. I'm with the law firm of Sniffen & Spellman, PA. I'm joined by my colleague, Jeff Slanker, also of our firm. I'd like to reserve 5 minutes for rebuttal.
So noted.
Your Honors, the trial court here erred when it found that the documents attached to the plaintiff's complaint constitute an express contract sufficient to waive sovereign immunity under the Supreme Court's holding in Pan Am. The Circuit Court's order is wholly inconsistent with decades of precedent on the sovereign immunity embedded in the state of Florida's Constitution. And the limited waiver of sovereign immunity contained in Section 76828 and for breach of contract claims the limited waiver of sovereign immunity that is permitted in accordance with the Pan Am case. And this court is well versed and very familiar with the underlying principles for sovereign immunity. First, it preserves the separation of powers between the 3 coordinate branches of state government. Second of all, sovereign immunity protects the public treasury. And third, sovereign immunity maintains the orderly administration of government. Waivers must be clear and unequivocal and are strictly construed in favor of the sovereign. And as this court recently found in the DeSantis versus FEA case, decisions of the executive branch during emergencies, such as the COVID emergency, must be afforded discretion under separation of powers principles. The Circuit Court respectfully failed to appreciate these bedrock principles by inferring contract terms into the nondescript documents attached to the complaint, citing Section 1009.24, which is the tuition and fees statute establishing tuition and fees that may be charged by members of the state university system, and propping up a contract where it simply does not exist.
Well, counsel, if I could ask, if I came into your law office, if a client came into your law office and said, I'd like some legal services, and you signed a piece of paper that said, you pay me $1,000 and you get legal services for trust in the state, whatever. Does it need to be anything more than that? It's a written agreement. It says X amount of dollars, you're going to provide legal services. It may be that some terms may be fleshed out later on, but the essential terms are there, aren't they? The service you're going to provide, legal services, and the price of it.
Yes, Your Honor. When you're dealing with the sovereign and you're contracting with the sovereign, you need more than that. The Castro decision from the 3rd DCA stands for that proposition, that you have to have an express contract, to have a meeting of the minds.
And then it's express written contract is what we're talking about, right?
Express written contract, right. Yes, Your Honor. That you have to have terms that are sufficiently definitive that the sovereign understands that it's entering into a contract. Here, there's no meeting of the minds, and I think where the Circuit Court particularly got it wrong is that it failed to recognize that a contract is more, especially a contract with a sovereign. A contract is more than just offer, acceptance, consideration. When we're talking about an express contract with a sovereign entity, issues like specificity, mutual assent to essential terms is required, and the Castro case talks about that. It talks about the need for the sovereign to have contracted essential terms. In that case, there was an agreement to provide certain kind of retirement services. And then the question became, was there a duty, some kind of contractual duty to provide correct advice by the entity? And the court said, that was not contracted for. Maybe in a private contractual setting, the example that Your Honor gave would fly, but when the sovereign enters into a contract, I think that's why the Supreme Court used the term express when it talked about the waiver, the limited waiver of sovereign immunity that will apply.
So what more should have been in this written agreement that was signed here, this written document that was, it said, I'm paying you for educational services. What more would make it a waiver of sovereign immunity?
If the court examines that financial liability agreement, and it's one of the attachments to the complaint, at most, all that the parties are agreeing to there is that a student will pay his or her tuition and fees, and that in exchange for that payment, the student will be granted enrollment as a student. There's nothing in that document at all that talks about that services would be provided by a specific date, that they would be provided in person or on campus. There's no promissory statements of any kind by UF in that document.
But I thought the written document said specifically for, quote, educational services, end quote.
Educational services, yes, Your Honor, but there's nothing specifying what those services are. Certainly
So for how many students are at the University of Florida? I've lost track.
I did too, Your Honor. When I was there, it was 34,000. I understand it's over 50,000
So
now.
there has to be 50,000 individual contracts, written express contracts for each student for them to have a cause of action, is what I'm hearing, because students' educational experience is going to be slightly different. They're going to take slightly different classes, slightly different lab fees.
Exactly.
Is that what you're saying?
I would agree with that, Your Honor. And the unilateral expectation of a student about various amenities that they're going to receive or various services that they're going to receive is not enough to form an express contract. In fact, there's no way that the University of Florida or any other state university in the state university system could live up to that promise. They attach also or cite the website that talks about the different services and amenities that are going to be provided. But consider the ramifications of an order like the circuit court's order or a finding by this court that there is an express contract here and that sovereign immunity has been waived. You take a student who really likes to swim, and she is absolutely enamored by the swimming facilities that the University of Florida has. And the swimming pool is closed for the semester. There's been a crack in the pool. It requires maintenance. Under their theory, under my friend's theory, what that means is that the university promised the service, it promised the pool. Her expectation is that there would be a pool, and then when the university failed to deliver, based upon these nondescript documents and a statute that says nothing about any kind of specific fee to be provided to students, that there's a breach of contract. Consumer class actions work like that in the private setting. When your cell phone bill has a charge on there for 12 cents and someone figures out that a service has not been delivered, you bring a consumer class action, you subpoena Verizon's records, and everyone gets that little card in the mail that says, hey, you can get your 12 cents back. When you're suing the sovereign, and when you talk about the types of services that the sovereign provides, the sovereign cannot live up to that type of scrutiny, and that's why sovereign immunity exists, to prevent the public treasury from being raided by class action lawsuits, as has happened here all around the state.
Let's take a step back and ask a question just about the university's obligations under the statute, right? So the statute that we're talking about, 1009.24, obliges the university to expend the student activity and service fees for lawful purposes to benefit the student body in general. Is that at all enforceable in any way? And let's set aside breach of contract. Let's say the University of Florida decides to, throw a big party for faculty with no benefit to the students whatsoever. And let's just argue that that doesn't benefit the students. How would that statutory right be enforced? Or obligation?
Well, I think, again, you would have to have an express contract in that scenario between students. But I think there the statute says that the funds shall be, under your example, Judge Rowe, the statute gives that directive. It says it shall be expended for students. And if it was expended for a faculty party, perhaps there would be some sort of statutory hook that a student could say, hey, you breached this obligation to me, you breached this statutory promise to me. But the types of promises that the plaintiff is seeking here are nowhere to be found in Section 1009.24. Universities are granted great discretion on how they spend the fees, when they spend the fees. The only exception is the financial aid fee that all students pay. That has to be expended in the same year. But fees are expended for all sorts of things. They're not their model, respectfully, is sort of a pay-as-you-go model. It's the gym was shut down for the day. I get my dollar back from the fees that I paid because I couldn't use the gym on that day. The services provided by a university are not pay-as-you-go or service on demand. There are fees that are expended for buildings. There are fees that are expended to pay individuals who work to provide services to students.
Yeah, but wouldn't all that work itself out at another stage of the litigation? We're here on a motion to dismiss.
Yes,
That's
sir.
the very front end of it, on this limited issue of whether there's an express written agreement. Certainly, if this case moved forward on that express written agreement idea, these other issues could be flushed out factually. I mean, you could have an express written agreement that has implied conditions to it that are discovered through the factual finding process, right?
Well, I think that would do violence to the Supreme Court's recent decision in Jackson. And that's why we're here early in this case, before extensive class discovery, before motions for class certification are filed. I think Jackson is a watershed case. Jackson says that sovereign immunity must be decided at the earliest possible opportunity, and to subject the University of Florida or any university to that type of class discovery does violence to the very reason we have sovereign immunity in the first place.
But there's also, Mr. Sniffen, Florida Supreme Court cases that talk about sometimes the determination of sovereign immunity can't be made until facts are developed. So, you know, certainly Jackson talked about it, and they did the rule amendment that allows interlocutory appeals to determine sovereign immunity. But sometimes certain claims of sovereign immunity, you need the case to progress a little bit. Now, here, looking at what was attached to the complaint, specifically the financial liability agreement, looking at the language, you know, I understand that past due student accounts will result in university registration and services being withheld in accordance with university regulations. Doesn't that language about services being withheld if the student doesn't pay contemplate that there is some obligation to provide services? I mean, you know, we're at the motion to dismiss stage. They've attached documents that contemplate there is some kind of agreement under which the student has to pay, and if they don't pay, the university can take action in certain ways. Isn't this enough to overcome the motion to dismiss stage?
I don't believe so, Your Honor, for a couple of reasons. First of all, because this is a breach of contract case, Rule 1.130 requires that they attach the contract. Number two, that financial services agreement, it read in its entirety, really only guarantees the student enrollment. Once you're enrolled, then you may be eligible for services. The term educational services isn't provided in that document, but I think read in context, it means you get to go to class and then you're going to get educational services such as that, and then other amenities. And that's a lot of what they're complaining about. They're saying that there's all these things that a student normally avails themselves of when they pay their tuition and their fees, and that they didn't get to enjoy that. I would commend the court to the Verdini decision out of the third DCA, which is on the exact same set of facts. And in that case, the court examined documents that are actually more specific and less nondescript than the documents attached to this contract or to this complaint, and held that those documents are not enough to amount to an express written contract sufficient to waive sovereign immunity. I think the Verdini case is exactly on point with respect to that issue. All that is guaranteed by that financial services agreement is enrollment. That's the only promise that the university makes, is that if you pay, you're enrolled. Once you're enrolled, you may get certain services. The second document, the tuition statement, that merely shows that there was a financial aid payment made for Mr. Rojas, and the website, which is provided to cast some sort of light upon what type of services these students, and Mr. Rojas specifically, expect. Those don't carry the day when we're talking about an express contract.
Well, when we're looking at an express contract where the government is the vendor, and, in contrast to Pan Am, when, we're not looking at a normal agency procurement for services, for telephone services or things of that nature, this is where the state is providing the services, is writing all of the documents that the consumer then has to either, take or leave. And I think, the overlay in the university system, you have students who are on Bright Futures and Florida Prepaid who must go to those state universities or within that kind of pool of educational providers. Doesn't that make the analysis different on what the express contract is and what the requirements are on a motion to dismiss?
I don't think so, Your Honor, because I think, and I see that I'm almost out of time, it's at the pleading stage. This court said in the City of Gainesville case that it's their burden to identify the express written contract at issue. Now, whether or not those are documents that they have no ability to bargain or negotiate or not, as Your Honor noted, they can either take them or they can leave them. But you still have to have the sufficient requisites. And I commend the court to the Castro case, where the Third District Court of Appeal, and also the Acosta case versus District Board of Trustees for Miami-Dade Community College, they both talk about the essential terms of the contract have to be identified in the contract in order to have a waiver of sovereign immunity. The nature of the relationship between state university students and their institutions is inherently not a contractual relationship. When you're dealing with a private university, it's a different story. Florida law has been clear for a long time that that's more of a contractual relationship. But when you consider all the touch points between a university and its students, some documents that look a little more contractual, some that probably look less contractual, that's extremely problematic when you consider all the documents exchanged between these types of parties and the ramifications of allowing students, every time they feel that a service wasn't provided or that something did not live up to their expectation, to be able to cobble these documents together and say, aha, I have a contract. Those types of promises are certainly not contained in the financial services agreement, and those essential terms, which are the things that they're complaining about in this case, are nowhere to be found in any of the documents attached to the complaint or Section 1009.24. If there's no other questions, I'll reserve the remainder of my time for rebuttal.
And counsel, you've gone over your time. I'm going to extend your time by an additional 4 minutes, and I'll ask the clerk to give the appellee 6 minutes, if my math is correct.
Thank you.
You're welcome.
Good morning, Your Honors. Adam Moskowitz on behalf of the appellee. Before I start, Mr. Sniffen and I have a bunch of these cases together, and he's been extremely cooperative and professional. I think I'm living in like Wizard of Oz or Alice in Wonderland. I just don't get it. After 2 years, I just don't understand. If a student said to University of Florida, well, I don't want to pay it. I don't want to pay the health fee or the athletic fee or the transportation fee. We're just talking about 3 fees that are on campus, taking the on-campus transportation, going to the on-campus athletic centers, or going to the on-campus health center. I don't want to pay it. There is no doubt, and they'll admit, Mr. Sniffen's going to tell you, they're kicked out of the school in 2 seconds. They're not allowed to stay. The contract says, as Your Honor read, it says, my right to register is expressly conditioned upon my agreement to pay all costs. So you got to pay these costs. We also produced to the trial court, there's billions of dollars in student debt that's gone after these students for the rest of their life. If you don't pay these bills, they don't just forgive you. They'll hound you until the end of the day. So to say that there's not some express contract between you and Mr. Rojas, when Mr. Rojas signed an agreement saying, I will pay this fee, but I will get that service back. And then he also did two other things. He attached the invoices. It says athletic fee. It says transportation fee. It says on-campus health fee. I'm paying for those fees. I didn't get that, so I want a refund back. And this has happened. Like, the world hasn't blown up. A lot of universities, a lot of states have settled these cases because they've said, yeah, you didn't provide those services. And to give you a little context, in the appellant's appendix at page 32, there's an order there, and you may try to wonder why. It's Rojas versus the Board of Governors, because that's what we first filed 2.5 years ago, and Mr. Sniffen was defense counsel. We said that all of these students, for all the public universities, have the same contract, which says you're going to have to pay these three, very specific, these three types of services, and then admittedly none of them were provided. So all we asked for is to those be credited back, and which wasn't mentioned by Mr. Sniffen in the underlying action is the judge in that case, Judge Gordon, he denied their motion to stay because what they argued is you don't need discovery, as Your Honor just said, you don't need any discovery on sovereign immunity. And the court said that is absolutely not true. You need to see what contracts there are, mainly because the University of Florida and these schools, they have the contracts in their computer system. Our students who had to pay thousands and thousands of dollars, they don't have a copy of the contract sometimes, or they don't have a contract of all the invoices. So you got to get it from the school. So what their tactic has been for 2 years is they go around the country, because first I sued the Board of Governors, one class action suit. Then they said, we're going to sanction you because you can't sue us because we don't collect the fee. The money eventually goes to the schools. So you have to go sue the schools individually in their own home venue. So I had to file a case in Gainesville, in Tallahassee, in Pasco County, and all these counties. I had to go to them. But in that first case, the court said, I deny your motion to stay, and I find that you need to produce the discovery to us. So Mr. Rojas got contracts. He got the agreements, which the First Circuit in Moore decision said, clearly at a motion to dismiss stage, you have a contract here. Not only do you have this agreement, which is so clear in its face, you must pay these costs, or you can't enroll, but we also have the specific invoices, and we have case law that says invoices can be combined to be an express contract. And then we have the statute, and the statute for University of Florida breaks down what those fees are. So I don't know when counsel's saying, well, we don't know what these fees are, and it could be for the pool. We're not alleging that the pool was closed one day. We're saying a specific fee that is identified in the bill for health, to have services on campus to open the health center. You had to pay $400. That was not open during COVID. There's no dispute. The transportation to bus you around the school, that was $580. I'm just giving the example. We have the amount. That was closed. The athletic fee to use the gym, that was closed for the whole semester.
And are you arguing that those funds were unexpended and undispersed?
Absolutely.
All right, so that leads to the statutory question I have. In relation to the activity fee, the statute says that unexpended funds and undispersed funds remaining at the end of the fiscal year shall be carried over and remain in the student activity and service fund. So why should those be refunded rather than carried over?
Absolutely, Your Honor. That's the exact point. It only says the student activity fee, which is identified in the records. That fee could be rolled over, right? It doesn't say, on purpose, anything about the transportation fee, which is a separate itemized receipt. It doesn't say anything about the health fee, and it doesn't say anything about the transportation fee. The athletic fee, you can roll over to the next year. It says the only thing you can roll over is the athletic fee, because that's more amorphous, it's more general, they can use it later. But you can't roll over the health fee, and courts have found that. You can't roll it over. It says you can't. And the statute says that if you have a fee which is called a specific item, this is in the statute, you have to use that amount of money for that fee. So if you say I'm paying $480 for a transportation fee, You have to give me $480, like your Honor's question, for the legal fees. You have to give me $480 for transportation. You can't kind of commingle it in some account and say, well, we used it for student activity fee. That's a separate fee that's charged and collected. This is a very narrow class action we filed against 7 different schools for 3 charges: transportation, health, and athletic. And that's it. We have invoices for each one of them. We have receipts for each one of them. So at this stage, on a motion to dismiss, as the court said in Moore, the First Circuit Court of Appeal, of course we state an express contract. He just mentioned Acosta. Acosta was on a summary judgment. There's no case on a motion to dismiss. So all the other cases, I mean, we're involved in them all. And we're trying to show the court what they were doing in the beginning, which was tying our hands and saying you can't get any discovery, as they did in this case. Motion to stay due to sovereign immunity. Thank God Judge Gordon in the prior case said, I disagree. I don't think that's the law. Clearly you're going to have to see if you have an agreement or not, so produce the agreements. We got them. We got the financial agreement. In some other cases, we don't have those agreements, and they've been able to kick our cases out. You haven't been able to show us the agreement. And it's crazy. I say, well, wait a minute, you have it. It'd probably take you 5 seconds to go into a computer and push it. But the courts have said sovereign immunity is so important in a few instances. I'm not going to allow any discovery.
And they're not public records because they're student records?
Sometimes, yeah, and sometimes you can request records, but other times we've tried to request all the students' records from the schools, and it's been a very arduous process, Judge. They've told us it's costing tens of thousands of dollars to pull up every receipt from a student. We've done that, though. But in this case, we have it. We have all the evidence. We have the invoices, the receipts, we have the statute that breaks down exactly what the fees are.
Well, let me cut to what I think is the core of the case, which is your theory of sovereign immunity in this particular matter. It seems to me that there's some documents here. You say they supported an explicit written agreement, okay? For purpose of sovereign immunity, that seems to me the question is, okay, there's these pieces of paper. Are they enough to establish a relationship, contractual relationship, and puts the sovereign on notice of the boundaries of its potential liability? Meaning, the whole purpose of a written contract is to have the parties' expectations reduced to writing.
Right.
So I think that's your theory here, which is that there's enough, at least at this stage of the litigation, to say, here's some writings, here's the parameters to it. We're not asking for all this, but this is all we're asking for, and they've waived sovereign immunity as to those things.
Yes, Your Honor, and that's what Judge Brasington found. She found that at this stage, they're definitely on notice. I'm going to charge you $432 to have an on-campus health clinic, okay? I have to provide that. You didn't provide it. Clearly, they're on notice now that they've collected the money from the student. They didn't provide that service. So it's pretty clear.
But there's a document that shows that. In other
Oh,
words,
absolutely. There's many documents. There's not only the overall agreement, but we have invoices. We have individual invoices showing I paid $433 for the transportation fee, and an invoice saying thank you for paying it. We're going to provide the services. I get the sovereign immunity part. I mean, it's like if University of Florida said to Apple, I want to buy 1,000 computers. And then the next day they said, well, you can't sue us for them because we're sovereign. How would that make sense? There's a contract. I will pay you X amount of dollars for contracts. For students, why would a student be treated so much worse when they're in such a weaker position? And there's no doubt, ask Mr. Sniffen, if Mr. Rojas said, I don't want to pay the athletic fee, that $422 during the semester, would he have been allowed to keep going? The answer is no. And ask him the question, if they owe it, if today they owe it, are you going to keep hounding him with collection agencies to go get it? Of course they're going to. So how can he say, well, there really was no meeting of the minds? That's, to me, the Alice in Wonderland. Of course there's a meeting of the mind. Every student had to pay the money. They paid the money. They owe the money. They're being hounded for the rest of their life for the money.
So what about the hypothetical of the student who says, hey, the pool was closed down, and I really wanted to go swimming?
I think that's probably more of the student athletic fee, that I think they do give discretion to courts if it's closed.
If we allow this case to move forward past the motion to dismiss, the response has been, well, we're going to have students who say, well, the yogurt shop wasn't open until 10 o'clock like it normally is, and I'm going to sue for that, or the pool was closed, or whatever. I mean, how do you respond to that?
Your Honor, it's a
Why
great
won't
question.
that happen?
I don't think it's a slippery slope because there are cases that says I didn't get the education I thought I was going to get. There are cases like that thrown out. There are cases where somebody says I thought I was going to get a better education, right? We're not even talking about in the COVID cases. There have been class actions brought saying I want my tuition back because an online education should cost me less than an in-person class. We're not alleging those allegations. And those have been upheld by courts around the country because a lot of the schools have brochures, even before COVID. If you want to do an online class, it costs X. If you want to do in person, it costs Y. So a school can't really say, well, we don't know how to quantify the differences. But on your point, Your Honor, there's a basic point to every student has a right. If there's an express contract that I'm going to pay $430, it's not a close call here. There's no dispute that the parking wasn't open, say, for half the time. That would have been a difficult question. Here, during COVID, they were closed completely. So the transportation, the health, and the athletic fee for on-campus environments were never provided. And it's pretty black and white. But we're not talking about hundreds of dollars. We're talking about millions, 30, 40, 50 million. If you start to put together all of the costs for just health, athletic, and transportation that these schools made the students already pay, we're talking a lot of money. I wouldn't take this case if it was $100 or if it was a silly your yogurt shop wasn't open. But these students call me because I teach at the University of Miami Law School, and these students are calling me saying, Adam, I owe $5,000. Why do I owe $5,000? I couldn't take the bus on campus. It was closed. So I have a lot of compassion for them, and that's why we tried with Mr. Sniffen 2 years ago to say, let's just settle this. Let's just quickly just rebate the students like Texas is doing and a lot of other states.
Well, I read somewhere, and I apologize if it was some other case, but I thought there was some assessment by the university, and like I said, I may be mixing up cases in another school, where they did make an assessment. They said, well, there's this $4.50, I'm making the number up, that it really ought to be refunded. Is that this case, or is that somewhere else?
That's another case.
Okay.
But absolutely. Yeah, there's schools in Florida that have said, we're rebating the money. 100%. We're going to rebate the money. We didn't provide for you a health center, so here's your money back. Or here's a credit back for next semester. There's states like Texas that said, we're rebating everybody in the state. So I don't know why the state of Florida decided, well, let's just hire outside lawyers, pay them millions of dollars, and just fight tooth and nail these cases instead of 2 years ago just saying, look, if we didn't provide these three services, let's give them a credit. And to this,
I think that's because they have the right to counsel and they have the right to make their arguments.
Of course.
So let's just move to the next point.
No, of course. It's my taxpayer dollars used to do it, but of course. So the only thing I would end is, Your Honor, is there's some basic principles of the Pan Am Supreme Court decision. There is no difference between what the Supreme Court said in terms of what would allege there's an express contract at this stage. Now, in our FIU case in Miami, I've already moved for class cert, and it was granted because the judge says, of course, it's the same exact question for every student. So I think that if Your Honors affirm the judge, we're going to move for class cert, it'll be granted in a month. I say we can go to trial in 3 months. We don't need anything else. He's saying we're going to somehow burden the school. We don't need it. They know how much was collected in the transportation, how much was collected for athletic, and how much was collected for health. They know that. They've told us that. So we could just go to a trial, a class certification trial, on behalf of the class of all University of Florida students who paid these 3 fees, and we want the money back. There's nothing else that needs to be done. We're not going to burden the school with some crazy, harassing discovery. We could be ready to go in 3 months for trial. If there's no other questions, thank you so much, Your Honors.
Thank you, counsel.
Thank you.
May it please the court, if it were only that easy. I have seen the very easy discovery that they serve and the wee little Chapter 119 requests that they serve, they're about that thick. So yes, they do take.
Well, we're just
thousands
here on a
of
motion to dismiss on sovereign immunity, so
Yes,
we're not going to.
sir. My friend has made this sound like just, all you got to do is just cut the check, give the rebate. It's not that easy. Services were provided during COVID. They weren't provided on campus. And my friend has not pointed to a single sentence in section 1009.24 or any of the documents attached to the complaint that say that they have to be provided on campus or in person, because it does not exist.
What about transportation?
Well, transportation, let's look at the statute, Your Honor. The statute,
Athletics?
he hedges his bets. He says, well, transportation, that's just to drive people around. And I don't know about the University of Miami, but that's not a sovereign entity either. That's not what transportation fees are statutorily designed to do. Okay, the transportation fees just have to be lawfully expended by universities for transportation. It may be putting a new blacktop on the parking lot. But you heard what he said. He said it was closed down for part of the time here. And make no mistake, there will be billboards around every university in this state saying, parking lot shut down, call this number. And the university had to shut it down for some reason or another.
Let's say the students paid this transportation fee, and let's say the transportation wasn't provided at all, just hypothetical. Isn't there enough of a written understanding in this case?
Nowhere,
about,
Your Honor.
There's not a document shows the transportation fee?
There's a receipt showing that a transportation fee was charged. But
And my hypothetical is that no transportation services were provided at all. They're out of luck?
the statute doesn't say you have to provide transportation fees by driving people around campus. The transportation fee can be used to pay people who were paid during COVID, who when the students come back, bring them around on the buses. It could be expended to fix the buses. It could be expended to buy new buses. It could be expended to make the parking lots more safe or more accessible. There's nothing, he has not pointed to a single statute or any document attached to the complaint. And I'm glad that he has said in this case that the documents attached to the complaint are an express contract. Well, let's look at those documents. Where in those documents or section 1009.24 does it say you have to expend them, you have to expend them now? Again, it's a pay-as-you-go model, okay? I pay this fee, I get this service right here, right now, on demand. That's not how universities work functionally. Those fees are designed for a whole host of things, to build buildings, to fix cracks in the ceiling, to do all sorts of things.
But it has a heads I win, tails you lose sort of component to it here. Like the students are entitled to have some thing in return for what they're paying, right, or not? You're saying it sounds like you're saying they get what they get.
The documents that are attached to the complaint say if you pay your fees and your tuition, that gives you a right to enrollment, and that is all. It doesn't say that you get to ride around on a bus. It doesn't say that you get these on campus. It doesn't even say that you get them in the same semester in which they're paid. They can be rolled over into different semesters, and you know, administrators sit down, sometimes students are involved in that, and they figure out how to take those fees and make students' lives better. And that's what they do. To describe the university as this heinous entity that was extracting money from students is insane. The university was bending over backwards trying to move instruction online because of a worldwide pandemic. The alternative would have been to say, well, we're just going to shut you out then. And your lives are going to be on hold for a year. But the university did what it did. He talks about the health fee. Students were receiving...
Counsel, I'm going to interject. Your time has expired. I'm going to give you about 30 seconds to
Thank
wrap
you,
up
Your Honor.
unless Judge Makar has any other questions. Thank you.
Thank you, Your Honor. I'll close with this. In the commercial class action context, what my friend says makes a lot of sense. But when you're suing a sovereign entity, you can't have raids on the public treasury. You cannot invade the province of the executive branch when it makes decisions like it did here. and it cannot, to make this litigation sound like it'll be simple, it'll just be a simple little case that'll be done in 3 months, doesn't recognize the reality of what class action litigation in this instance would be. We thank you for your time.
Thank you, counsel. Thank you all. We will stand in short recess. Please join us in the rotunda for coffee.
All rise.
Here's the claimant. Yeah. Beautiful. My house. It's bullshit. I have 4 kids. 40 acres. You don't have to worry. Not worried about running down the mountain. We don't during COVID. Well, yeah, I was going to say I'd go back. Thank you. Yeah, safe travel. Thank you. Yeah, thank you. You too.
All rise.
Please be seated. Good afternoon. Welcome again to the First District. We have the remaining two cases on our docket. The first one is Rodman versus Dead Bug Edwards, Praetorian Insurance Company, 21-2456. Counsel, you prepared? Please approach. Would you like to reserve any time?
Yes, I'll reserve 3 minutes for rebuttal.
Okay, thank you.
Thank you. May it please the court, my name is Bill McCabe. I represent the claimant Lyndon Rodman. And there are two issues on this appeal. The first one is, did the judge of compensation claims err in finding the employer carrier is not required to purchase a modified home, but need only rent one? Second issue is whether the judge of compensation claims erred in failing to order the employer carrier to provide certain modifications to claimant's home. As to the first issue, the employer carrier is authorized a home that is ADA compliant with suitable handicap modifications. And the parties also stipulated that the house the claimant was living in prior to his accident cannot be modified. So he's obviously got to get a new living environment. Right now he's living in a 2-bedroom handicapped accessible extended stay hotel room.
This is a workers' comp case. If it wasn't a workers' comp case and there was a judgment that said, thou shalt provide accessible housing or pay damages so they can get their own accessible housing, we'd have a pretty clear way of evaluating the case. But because it's a workers' comp case, there doesn't seem to be a whole lot of direction on what we're supposed to do in this situation. I want you to kind of address that, because it seems to me, this is me speaking, but what I see is a remedy has been ordered. This is medically necessary. Has to have a home that is modified for the wheelchair and so forth.
Right.
I mean, there's no dispute about that.
Right.
And the only dispute is about, well, where is the accessible housing and why hasn't it been provided? And what are we to do with it at this point? So
Well,
what's your
the
answer?
issue, I'm not aware of any Florida case either. Actually, I'm not aware of any case, but where it decides whether the employer carrier is supposed to purchase a house versus renting one. So I would submit that a determination of whether they should do one or the other would be based on the facts of a particular case. And in this particular case, the only evidence really is that they've got to purchase one. The employer carrier hired a real estate agent to try to find suitable housing, and he testified that there's no suitable housing to rent that can be modified to meet the needs of the claimant. So I think he found one initially, and by the time before anybody even went out and saw it, it was gobbled up. So he says the rental market's gone. So based on their own agents, if you will, testimony, a house has to be purchased for the claimant and not rented.
Well, the JCC's order kind of left that some wiggle room there, saying if you find a rental, great, but if not, you need to maybe buy one. But it didn't say you have to buy one. It didn't say you have to rent one. It kind of left it vague.
That's true. It could be either way according to the way the order is, but we submit he should have just ordered them to purchase a home. It's a waste of time to look for rental property since none of it exists, number one. Number two, it would be way more stable for the claimant if the claimant was in a home that was purchased, because if he's in a home that's purchased, he can stay there for as long as they want to stay there. If it's a rental property, you can rent it for a year. The landlord might decide they don't want to renew the lease. The claimant would then have to move out of that. They'd have to go through the same process that they're going through right now, which would be trying to find suitable rental property, of which there isn't any. Is the property, can it be modified to meet the needs of this particular claimant? The rent might keep going up.
Well, I'm just struggling with what an appellate court, what we're supposed to do in looking at this order, because the order does say, gives the opportunity for the employer carrier to fulfill its obligation, which it has not done yet, right? I mean, that's stipulated, right? They have to do this. They haven't done it yet. So are you asking us, you want us to remand the case and require the JCC to specifically order you must buy a home.
Yes, I think the court should enter an order saying that the judge erred or abused his discretion in not directing the employer carrier to purchase a home for this particular claimant that can be modified to meet the needs of the particular claimant, because there's no rental property and there's no point in wasting time. So I think this court should find that the judge abused his discretion in giving the employer carrier the option still of either purchasing or renting, having the realtor waste his time trying to find rental property. Plus, as I pointed out, if a house is purchased for this claimant, it definitely would ameliorate, if you will, or mitigate the effects of his particular injury, because if he has to keep moving from year to year or every two, who knows how often he might have to move, that clearly is not good for the claimant. I might point out, too, that one of the defenses the employer carrier actually put in there is that they were attempting to locate a long-term home. Well, the only way they're really going to find a long-term home is if they purchase one.
Now, how would it work? As I understand it, the JCC requires $1,500 a month to be provided by the claimant, right? When there's some determination of about
Yes.
So this isn't like you get a free house. They do have to put some money in. So if it's bought, how would that $1,500?
The $1,500 would have to go toward either the rental or the purchase of a home. The claimant's got to pay the $1,500 because he has to pay the amount of money he was paying prior to the accident occurring.
And he's not paying anything for the current arrangement.
Current arrangement, he's not paying anything right now. The employer carrier, they're paying $4,000 a month to rent this hotel. So I really don't understand why the employer carrier wouldn't want to purchase a home, because if they purchase a home, they might only have to make the modifications to the home one time. The claimant's going to remain there. If they rent a home and the landlord decides they don't want to renew the lease or something like that, then they're going to have to find another home. They're going to have to modify that. They're going to have to, the rent might go up. I mean, to me, it doesn't make any sense why the employer carrier wouldn't want to purchase a home anyway. So, yes, to answer your question, I think this court should enter an order saying that the judge of compensation claims abused his discretion in not directing the employer carrier to purchase a home that's modifiable for this claimant.
Given what you would say is the undisputed evidence that in this South Florida, Miami area rental market, there's nothing to be rented.
That's the undisputed evidence, and it's from their own real estate expert. So now the second issue in this too is we submit that the judge erred in failing to direct the employer carrier to at least make sure that there were 8 modifiable issues that the expert testified to, and that the only 2 doctors to render an opinion in this case said that they were medically necessary to order the employer carrier to provide those things, which are such things as, widened doorways, certain kitchen washer dryer stuff, driveways so the claimant could get in and out of the house, generators. They're all listed in the brief. There was 8 of them. And the reason that the judge rejected the claimant's argument there is the judge said it was speculative because a particular house hadn't been picked out yet. But it doesn't matter what house is picked out. No matter which one it is, it's going to have at least these 8 items to make it compliant for the claimant. And that testimony is unrefuted, and it's medically necessary according to the doctors. So without that, I don't know how you could find a rentable home even if you don't know what modifications need to be made to it. And the employer carrier has agreed to provide ADA-compliant homes that's modifiable for this claimant, but yet they don't agree to any particular.
Well, your point is that what's the harm? In fact, there may be a benefit of having these 8 things specified because the employer carrier already knows they have to have these 8 things. So why hold back on it? Why keep it out of the order?
Exactly. They haven't agreed to any specific modifications, and I don't understand why they wouldn't agree to, and why the judge didn't order that at least these minimum 8 modifications be provided. And then that way I think it would make the search, too, for a home to purchase and even a home to rent if the court believes it that way. When you know at least these items have to be modified, is this house capable of having these modifications? So we submit the judge erred in not ordering at least those 8 items. And there might be more when they get into a house, and once the claimant's in there might be some other items that also need to be modified, which can be dealt with when a specific home is located. But for now, these 8 should have been ordered, and if a house has 1 or 2 of these things already, then of course they don't have to redo it because it's already there. But, so we feel the judge erred in that too, and we would request that the court enter an order.
Remind me, the claimant here has 24/7 care, meaning,
Yes, he does.
okay, that was ordered as well.
Yes,
Okay.
yes. So I'll reserve the rest of my time for rebuttal.
Okay,
Thank you.
thank you. You have 5 minutes.
Good afternoon. May it please the court. Teresa Savone on behalf of the Appellees, the employer carrier in this workers' compensation case, Deadbud Edwards Praetorian Insurance Company. This court should affirm the JCC's final compensation order because the JCC did not abuse his discretion as it relates to the housing environment for the claimant, Mr. Rodman. Judge Makar, I'd like to start with one of the things that you mentioned right off when my colleague was making his argument. You indicated there was a remedy that was ordered. That is correct. You indicated that the remedy, specifically a housing alternative for the appellant, was medically necessary, and I would like to correct something. The JCC specifically found that there was no evidence of medical necessity in this case. The only issue, issue 1, and even as my colleague had indicated, is not whether there was compliance with the order. The issue on appeal is whether the JCC abused his discretion by not requiring the appellees, the employer carrier, to purchase a home under workers' compensation benefits.
Well, isn't it medically necessary to have an accessible home?
I'm sorry, can you repeat
Isn't
that?
it medically necessary to have an accessible home? If I'm wheelchair bound and the wheelchair can't get through the doorway, I'm not going to be able to get the remedial care by living in that home.
I don't think we're going to disagree that if someone like the appellant who is paralyzed will need an accessible living environment, which has been provided since the appellant moved back to South Florida in September 2019. So the question of whether furnishing a suitable living environment, whether that's occurred, that has occurred. So under purposes for the statute for 440.13 sub 2A, the employer carrier has complied with furnishing a suitable living environment. However, in this case, when we talk about the evidence, which is the issue on appeal, whether there was competent substantial evidence to support a workers' compensation benefit. And Judge Makar, as you indicated, workers' compensation.
Well, you're confusing me. It sounds to me like you're contesting whether that you even have to provide a rental or a housing. He can just stay in the motel, is what I'm hearing.
No, and I apologize if that is the interpretation of my argument. The employer carrier is not saying it does not have to provide housing. It has provided housing. It is whether you have to purchase versus rent. And when we talk about workers' compensation benefits, that burden of demonstrating entitlement to those benefits under Chapter 440, that falls squarely on the claimant.
I'm still confused. I thought that it was agreed to by everyone here that this gentleman, the claimant, had to have a home, rented or owned, doesn't matter, that's accessible to him so that his family can be with him and provide this additional support and care. Right?
The employer,
And he can't get that living in a motel.
The employer carrier agreed to provide an ADA compliant home. However, the issue of the medical necessity was questioned, and that's why the JCC specifically said there was no evidence that it was medically necessary to purchase, not to provide a home, not to furnish a living environment. And I think maybe that's the important distinction. It's not that we are saying we don't have to provide a suitable living environment. Under
Okay, well,
the
let me figure this out. You've got to provide something that's either purchased or rented. A 3-bedroom, 2-bath, right, if I recall. Correct? Am I right?
Correct. Okay.
That's what you've got, your employer carrier has to do.
Correct.
That's the remedy. It hasn't done that, right?
Correct.
And what they're saying is that the evidence in this case shows the rental market doesn't exist. So therefore, the JCC erred by not saying you have to purchase something. I mean, that's to me, that's as simple, to me, that's my simple view of the case.
And I understand that. And looking at the evidentiary standard for medical necessity, this court has specifically said that the initial inquiry to determine the validity of benefits in a workers' compensation case is the validity of the benefits. And that for purposes, and this court said in the Adams Building Materials versus Burks case, for purposes of providing a new home, and in that case it was a construction of a home, so a little different circumstances, but for purposes of providing a new home, this court said the new house must be medically necessary. And we have a finding from the JCC saying there was no evidence. Appellant has agreed in his initial brief that there was no medical testimony that was provided. The appellant agrees in his initial brief that Mr. Gebauer, who was a real estate broker.
I don't know, it's just me. I'm not talking for my colleagues, but I don't understand that argument at all. You have an obligation to provide this ADA compliant home. It hasn't been done. It's medically necessary that he be put into this environment for his well-being. So to me, it's on appeal, at least, it doesn't seem to me that this medical necessity issue, to me, this doesn't seem to be relevant at all. What is relevant is that the employer carrier isn't fulfilling its obligation to provide the type of housing that's agreed to provide and that everyone agrees is necessary.
And I think maybe that is the position that the parties took in the brief, and specifically that my colleague took in his initial brief, was that they erred because the appellant's argument was there was testimony, and that focus was on Mr. Gebauer's testimony. But they said that testimony was not medical testimony. The focus in the brief was purchasing versus rent. We are challenging the medical necessity because the JCC specifically said there was no evidence as to medical necessity. And that's at the record at page 27. And
But
that's
isn't that error? I mean, it seems to me that's an erroneous finding.
I would respectfully disagree based on the standards that have been set forth by this court in other workers' compensation cases, because the only testimony that was relied on by the appellant at the JCC level was the testimony of Mr. Gebauer. Mr. Gebauer is not a physician, is not a licensed healthcare provider. In other cases, such as the Adams Building Materials case that I just referenced, we were talking about, in that case, there was a physician who testified and said, this case.
But the medical necessity has already been determined. He has to be in an ADA home, ADA compliant home. That's done. That's over with. This case is not about that. This case is about what the employer carries obligation to do in providing that.
And in providing that, and if that's the route that this court is taking, then the employer carrier has provided a suitable living environment, and that is the requirement.
No,
Furnish.
I think we're going in circles on that. I don't understand the argument.
Well, and the argument is the claimant has a burden to demonstrate medical necessity. Medical necessity requires medical testimony and medical evidence. This court, in several cases, in workers' compensation cases, has reversed and remanded where the JCC has provided housing.
So you're still looking for a rental home. You're still, not you, I mean your client, but you're still looking for a house to buy, I assume. You're looking out there, and month after month, maybe year after year is going by, and this gentleman's still sitting in the motel room. And that's not medically compliant, because the testimony was that he needs to have a home that's ADA accessible so he can have his family with him to provide care and support. So how long can this go on?
Well, and I don't have an answer to how long it could go on.
Well, it sounds like you're fine with this going on year after year after year because, well, it's not medically necessary.
Well, and I don't think that's exactly what my argument is.
Let's hear it.
The argument is that we have been furnishing, the employer carrier has been furnishing a suitable living environment. That is what is required under the statute. There is no requirement under the statute, and Judge Maker, as you indicated, you said, what are we supposed to do in this case? Because the statute doesn't say you have to purchase a home. The statute doesn't say you have to rent a home. It doesn't say you have to provide a hotel room. It says furnish. And that is exactly what the employer carrier did while the case was going on, while the petition for benefits was going on before the final determination by the JCC. And that was at no cost to Mr. Rodman.
Well, I mean, it's a silly example, but let's say you have to provide oxygen. You can rent a tank or you can buy a tank. Well, the rental market's tied up. We can't rent oxygen. Well, you can't be forcing us to buy oxygen, can you? I mean, at some point, it seems like the argument collapses on itself and the employer carrier has an obligation to do something beyond what it's doing currently, which is not adequate.
Well, and I think that's where I will respectfully disagree with you, Your Honor, is because the issue that was raised by appellant in the initial brief has to do with whether they're required to purchase, not whether they're required to comply with what the final compensation order says at this moment. The requirement of purchasing, and again, the JCC specifically found there was no evidence that this was medically necessary, and that is why that is our argument, respectfully, Your Honor. I know we may be at some disagreement at that, but that is the argument because that was the finding by the JCC. And this court, in order for this court to agree with the appellant, this court must find that there's competent substantial evidence in the record to demonstrate medical necessity for a workers' compensation benefit. That is what's required by this court's own case law. That's what is required by this court's own interpretation of 440.13(2)A for purposes of providing housing alternatives to claimants. So I understand there is a frustration by this panel as to potentially what is going to happen to this specific claimant and why hasn't the employer carrier done that. I understand that frustration, Your Honor. That being said, the arguments that are raised in the brief and that were also raised in our answer brief in response has to do with what is required in order for a claimant to obtain those benefits. And we have the appellant, and again, and I understand, Judge Makar, you may disagree with this argument, but this is about his burden, the claimant's burden, to demonstrate medical necessity, specifically because the JCC found there was no evidence of medical necessity. So I understand I've spent the majority of my time.
What about the second issue?
Sure.
Unless my colleagues have questions on it.
In the second issue, as to the modifications, the final compensation order in the JCC specifically reserved jurisdiction on that. This court has found in workers' compensation cases, in numerous workers' compensation cases, that where a JCC reserves jurisdiction on an issue, that issue is a non-final, non-appealable issue or order, depending on if it's the only issue or if it's one of the issues, that this court doesn't have jurisdiction. And this court has dismissed those cases. Now, and that's from the Betancourt versus Sears Roebuck case. And specifically, my colleague in his reply brief had said, well, the Betancourt case shouldn't apply because there's Estech General Chemicals versus Graham. However, I would note to this court that the Betancourt case was an en banc decision by this very court, and in that en banc decision disapproved and receded from the line of cases, specifically the Estech General case. So,
well, I'm sorry to interrupt you, but on the second issue, in my mind, all we're talking about is they want the order to have said, in your pursuit, your client's pursuit of rental housing or owning or buying a home, these 8 things need to be explicitly required. Else, you could come back with a rental that has only 6 of those things possible, or maybe 5. So why not just have these 8 things spelled out? Because your client agrees to these 8 things, right?
To be very candid with the court, at the trial, my client indicated that we weren't necessarily saying that he's not going to need widened doorways. It was, once we have a home, let's see if that home has those widened doorways. Because if there's widened doorways already in this home, there's nothing to be modified. If the home has...
But that's circular, because if you have the 8 things, if you're put out there, needed home has to have these 8 things, you're going to get more compliance from properties that fit the bill than if you say, hey, you need a home, and then have to figure out and go out and figure out whether the 8
Well,
things
again,
are...
the JCC, and I didn't mean to cut you off, Judge Makar, the
No, that's
JCC specifically reserved jurisdiction on the modification and said, even if I'm going to address this, this is speculative because we don't have a home. So
But in that error, it's not speculative. These 8 things have to be done.
I disagree. I don't believe it's error because initially the JCC says, I don't even have to reach this. I'm reserving jurisdiction on it. So the fact that the JCC has reserved jurisdiction on an issue, this court can't decide that issue. And that, again, is from the Betancourt case, the en banc decision. So, and I see I'm close to running out my time. Unless there are any other further questions.
Well, I hope, I didn't mean to monopolize it, but you've got a minute and 35 seconds.
Right. So just to briefly conclude, as to the first issue, we would respectfully request this court affirm. The JCC cannot require the employer carrier to purchase versus rent a home for the reasons articulated today in our brief. And as to issue 2, We respectfully request this court dismiss that part of this appeal because this court lacks jurisdiction. Thank you.
Okay, thank you, counsel.
Just a couple of things in rebuttal, because the sole basis of the judge's rejection of claimant's contention that the house should be purchased instead of rented is because there's no medical evidence was presented that it was medically necessary for the employer carrier to purchase rather than rent a modified home. But that's not a medical necessity issue. I agree with the questioning that you were asking. The medical necessity was whether it's medically necessary for the claimant to have a modifiable home within the ADA guidelines, and everybody agreed to that. Now, the issue now is how does the employer carrier furnish that particular home? And that's really not a medical issue, it's a real estate issue. What's out there? The only thing that's out there is for a home to be purchased. And that's unrefuted testimony, and there's no basis for the judge to have rejected the unrefuted testimony from their real estate agent that the only way to furnish this medically necessary home for this claimant is to purchase it and not rent it. And then as far as the second point, their argument that the judge reserved jurisdiction and therefore this court doesn't have jurisdiction, the Betancourt case does give them some support for that argument, but my position is that the judge of compensation claims is also required to rule on all issues that are ripe for adjudication. And clearly, when the employer carrier has to find an ADA compliant home for this claimant, and the unrefuted testimony from the construction man and from the two doctors who rendered an opinion is that the home has to be able to be modified to include at a minimum these 8 items, it's error for the judge of compensation claims to not order the employer carrier to provide those 8 items at a minimum for any house that is provided for the claimant. And again, as I said before, if you don't know what's going to go into the house to modify it, it's really going to make it kind of hard to find a house that's suitable for the necessary modifications.
What discretion does the employer carrier have? And I perhaps should have asked your other counsel earlier, but suppose there's a 4-2 home available. It only needs a 3-2, but the 4-2 is available and it costs less than the 3-2. What discretion does the employer carrier have in these situations to comply, even if it isn't fitting it to a T?
Well, I would say that the employer carrier would have to provide at a minimum what the judge ordered, which is a 3-bedroom, 2-bath. If they can find a 4-bedroom, 2-bath that suits everybody, that's modifiable, fine. And they're not providing what the judge ordered right now. They are paying for where the claimant's living, as I indicated before, but it doesn't fit within the parameters of what the judge ordered them to provide. So, thank you very much.
All right, counsel, thank you. Case is submitted. All right, the next case we have is Summerlin versus L3 Communications, 21-3561. Counsel, please proceed.
All right, may it please the court, my name is Ashley Richardson. I'm representing the appellant Brandy Summerlin in this case. I'd like to reserve 4 minutes for my rebuttal, please.
Very good.
So the issue before the court is the order of the trial court dismissing with prejudice my client's 3rd amended complaint. In that complaint, she brings 2 causes of action, one for associational discrimination and another for retaliation. The trial court had 2 bases for dismissing the complaint with prejudice. The first one was that she failed to exhaust her administrative remedies. In the 3rd amended complaint, she alleges that she has exhausted her administrative remedies. But
let me ask you about that, Ms. Richardson. I've got the complaint up. It says conditions preceding. Plaintiff has satisfied all conditions preceding to bringing this action. And if it had stopped there, I agree with you. The rule allows just that, but it goes on. It says, in that, plaintiff filed a charge of discrimination with the Florida Commission on Human Relations and with the EEOC. So by virtue of adding that additional language, does that not allow them to bring in that charge?
I would disagree that it's, because the way they've framed the argument is that it is the document upon which her complaint is brought. Kind of similar to if this was a contract dispute, we would need to file the contract. That's not necessarily the case here.
Well, I think I agree with you. I think that rule can't mean conditions preceding, documents related to conditions preceding should be attached, because the rule before says you don't have to attach them if you say generally you've complied with it. But my question is a slight bit different. My question is, you said it generally, but then you also said, we filed this charge. And then they've appended the charge to their motion to dismiss. So why does that not volunteer the charge and bring it into the analysis by the trial court?
I would say our only argument in that respect is the one that I just made, that it's not actually the instrument upon which it's brought. I think the bigger argument is more that once the charge, let's just take it a step further, once the charge actually is included, and we're going to call it part of the sort of four corners of the complaint, was the remainder of the decision that the trial court issued as to whether or not the charge itself was sufficient to exhaust her administrative remedies is sort of the larger issue. Because my only argument in respect to what you've just asked is just that it isn't the operative document.
So, and just so I understand, you would say the rule says you can generally state conditions preceding have been met.
Correct.
And that's enough by itself, by virtue of operation of the rules of procedure, correct? And then you would also say that under 1130, what that rule is referencing is the corpus of the claim. If it's a contract claim, that's a contract. If it's on a note, that's a note. If it's a mortgage claim, it's on the mortgage. Your claim is not predicated upon the charge.
Correct.
They would say, well, your standing is predicated upon the charge, and that leads me to Teal, among others. I think that's the second DCA case. And the second talked about standing. I'm not sure I agree it was standing in that case, but they said that where there is reference to a document in a complaint, it was perfectly permissible to allow that document to be used against the claimant on standing. What would you say about that case, if you know the case I'm speaking of?
I have a sort of vague familiarity with it, and I mean, to an extent, I don't necessarily disagree with that. Again, it goes back to the sort of the perfect analysis you just offered immediately prior to that, which is our entire position on that one specific issue. Here, I would argue that if we're going to find that Teal sort of does govern in that sense, in the way you've just explained it, that because we've referenced the document, it's now part of the complaint itself. There are bigger issues here that then come after the inclusion of that document. So it's sort of not necessarily the focal point of what our issue is with the trial court's order.
Are you familiar with any other rule of procedure other than the two involved in this analysis, 1120 and 1130, that would potentially allow a defendant to inject a document like a charge into a motion to dismiss analysis?
Admittedly, no. No other rule would come to mind on that particular issue. So once we sort of move past whether or not the charge actually is properly included, and we'll just say for the sake of this next portion of the argument that it is, or that it's at least been considered by the trial court, the bigger issue then is that her complaint it has two causes of action, as I said, associational discrimination and retaliation. Her charge of discrimination, which I think is at page 118 of the record, checks the box for other, because there is no preset characteristic for associational discrimination, and next to other, she writes associational. And then in the particular section, she describes the fact that she and her husband, Kevin Summerlin, were terminated on the same day, and that she was essentially the innocent bystander to the discrimination and retaliation that he experienced. She specifically references in that charge that he was the victim of discrimination and retaliation, and she mentions that he too has filed a charge of discrimination that is under investigation with the EEOC at that time.
So to understand what you're saying on behalf of your client, one, you're saying it should have never been considered. It's ancillary, irrelevant to the analysis on a motion to dismiss. And second, even if it was considered, it's not enough to invalidate her ability to bring this claim.
Correct. That the charge, I'm sorry.
Well, and help me, help the panel understand, what cases are there, Florida cases, if you have them, that would say that a charge like this, the charge that was appended to the motion to dismiss, was a good enough thing to allow entry into the areas that were referenced in the charge?
Well, we start with the Gregory case, which I believe is an 11th Circuit case, but it's, we model all of our Florida law off, after all of the federal laws. First and foremost, the whole checking of the box issue, we have that in quotes in a ton of cases right now, is that those boxes are not necessarily dispositive. It's the complaint taken as a whole. What does it tell the EEOC it's supposed to investigate? What does it tell the employer they're being accused of? And is the document itself sufficient to state that? And I also have Batson, Sanchez, Turner, and then again Gregory, which sort of gets into the issue of what's reasonably expected to grow out of that charge of discrimination, which is again where her reference to her husband's charge.
Is that the standard? What is reasonably
expected to grow from the charge? So, and I know counsel filed a number of cases that sort of speak to the opposite of that in their answer brief, which is, let's say, for example, she had checked gender discrimination and shown up in court with a disability discrimination case. Those two don't match. We're essentially trying to get the charge and the complaint to look the same, so there's no surprises at the end. It's a very rudimentary way of explaining it. So if we, for example, she doesn't check the correct box, but this narrative portion explains what her charge is, can the EEOC be reasonably expected to pull her complaint, sort of final document, out of what she filed with them? So that's the reasonably expected to grow.
I see also in this charge, and I'm going to ask counsel for the employer about this too, there's a reference to her husband's charge.
Correct.
Is that germane to our analysis?
I think that it is, and that's our position. So we've got, it kind of brings us back to, if we're including this charge of discrimination as now part of the four corners of the complaint, she specifically references his charge of discrimination. So what the trial court has done is review just her charge and said, you didn't check gender, disability, age, or retaliation, which are her husband's claims. She references the charge in her charge. And if you flip to, I believe it's page 174, we actually attempted to file that below. He checks all of the boxes for his protected characteristics. She is not bringing gender, disability, age, or retaliation. She's bringing associational claims. So referencing his charge alerts the EEOC and the employer to the fact that he experienced workplace discrimination and retaliation, and she was the bystander victim of that discrimination and retaliation. So it's sort of, if we're going to look at one, we have to look at the other because it's essentially part of the same nexus. So that's issue the first, is what's reasonably expected to grow out of that charge of discrimination to show that she actually exhausted her administrative remedies. And then the second issue, which the court was sort of a little bit more generic in its findings, is that whether or not the claims themselves were legally or factually sufficient based on what was the actual allegations in the charge. So we have the issue of whether or not the claims exist in the first place for certain types of associational discrimination, and then whether the facts were sufficient to state those causes of action.
Well, it's clear under the ADA, obviously the language, it's explicit. What characteristics in the record here show that the husband fell within the ADA? What, I mean, in terms of the
Essentially, like what was his disability, essentially?
Yeah, right.
So in the complaint, I believe it starts at the record on page 94, excuse me. He describes that in 2014, he started to suffer from severe stress that manifested with certain physical symptoms, heart issues, migraines, ulcers, and he wound up in the hospital. So it's really contained within that paragraph that he experienced these sort of ongoing health conditions that affected his ability to work.
And is that's ADA sufficient?
The ADA, as amended in 2008, is much more liberal than it's the case law that predates it, and it's anything that's going to substantially limit you in one of the major life activities, which does include working.
Weren't they monitoring his vital signs at work?
One of his, I believe his supervisor for approximately 4 to 6 weeks, as it's alleged in the case, was monitoring his, I believe he had to go to get his vital signs taken several times a day following that hospitalization period.
Was that employer required? Is that?
Yeah, essentially the supervisor was requiring it. And I see that I'm up against my 4 minutes. So if we have,
You can use more of it if you want, but then you use less of it.
I was going to say just briefly. Just briefly, so we have that ADA is going to allow an associational claim. The other three, there is no law saying, or there's no case law saying explicitly that we don't have claims for associational retaliation or age or gender. And in fact, most of the cases, that the few that there are, lean towards a finding that those characteristics would be protected. So we have associational race discrimination claims based on Title VII. Well, there's no difference. It's just a line of protected categories. We have race, we have gender. So we would see that there's no difference essentially between associational race discrimination and associational gender discrimination. And the facts more than sufficiently state claims for each of those. So if there are no questions, I'm going to save my remaining time.
All right, thank you.
May it please the Court, Eric Delichka and Jennifer Richardson for the appellees. I would like to start out with the issue that was first addressed about the incorporation of the charge. It's an incorporation of charge by reference, which is a legal principle that has been acknowledged both by state courts and federal courts. And if you look at the cases that we cite in our appellate brief, you will see at least 24 cases where they deal with a motion to dismiss case.
And I read those cases. I read the supplemental provision too, which I believe you provided to the trial court. I read the cases. Let's start with paragraph 5.
Okay.
In paragraph 5 of the complaint, as I read before, says the plaintiff has satisfied all conditions preceding to bringing this action. If they had stopped there, is that enough to establish the conditions preceding in accord with Rule 1.120C?
If you read the rule literally, if they had stopped there, they may have had an argument. The issue I take with that is that when you look
let's look at the rule. It says conditions preceding. In pleading the performance or occurrence of conditions preceding, it is sufficient to aver generally, allege generally, that all conditions preceding have been performed or have occurred. Well, they did that, did they not?
They went beyond that and referenced the charge.
Well,
and I agree, yes, they did allege.
If they had put a period at the end with the general, that would have been a good enough thing.
Absolutely.
So your problem, as I asked counsel about, is this addition of the reference to the charge. And you think that would then allow the defendant to append that charge to the motion to dismiss?
Correct, because that reference to the charge is not by accident. It is not an ancillary allegation. If you look at the cases that we cite to, whether state court cases or the federal cases that we cited to, the courts say that it is a precondition to bringing a claim in court, that you exhaust your administrative remedy by filing a timely charge of discrimination. So by referencing the charge, in some of the cases, there are no charges attached. There are no allegations made. It is brought up on a motion to dismiss based on an affirmative defense, which courts have recognized that if you have a document that is dispositive on a motion to dismiss, it can be referenced if it's not in dispute. And there's no dispute as to that charge or what's contained in the charge. What's in dispute is the interpretation of whether it reasonably grows out of the charge, these new charges of retaliation that appear in the third amended complaint.
You agree that's the standard, reasonably grows out of the charge? Out
of the charge, yes. Okay. That's out of Gregory and subsequent cases. We cite to cases for that proposition as well.
Let's come back to procedure again.
Sure.
where in the rules of procedure does it allow a trial court or this court to evaluate something that is not included as part of the plaintiff's complaint, attached to the plaintiff's complaint? Where is that included?
If you're looking for a specific rule, I can't cite to one. If you look at the cases interpreting the rules, the 5 cases that we cite that are state court cases, they do exactly that because it is the principle of incorporation by reference. If you refer to a document that is not just an ancillary document in the complaint, it is incorporated by reference into the 4 corners of the complaint. And that's judicial interpretation, but I can't cite to a specific rule that says that can occur.
Well, and that's my question. I think I've read all the cases you cited, but I didn't see a rule of procedure referenced in those cases, the Florida cases.
Correct.
Are you familiar with the rule of procedure that would allow a trial court to do this?
No.
And I know the argument below was under 1130, that it was, I guess, again, to use the language of the rule, it says documents on which the action may be brought. So is it your position on appeal and your position below that this charge was a document on which the action may be brought?
Yes.
And why is that?
Because the case law it says that consistently, whether it's Gregory or any of the others, is that you have to look at the charge of discrimination. The charge of discrimination then defines what can be brought in court subsequent to the administrative process. Otherwise, you're opening up the floodgates and ignoring the purpose of either Title VII or the Florida Civil Rights Act, which was dropped after the first complaint. But if you look at Title VII, the purpose is, 1, to adequately notice the EEOC and the employer of what the allegation is, and 2nd, an opportunity to go through the conciliation process at the administrative stage. And that's important because the reason why you have that is to avoid unnecessary litigation if EEOC and the defendant is properly informed of what the allegations are to meaningfully engage in the conciliation process at the EEOC administrative level.
Let me ask you a question, and it has to do with my background. I was a medical malpractice defense lawyer. As a predicate for a medical malpractice claim, as a condition precedent to bringing a medical malpractice claim, you may be aware of this, you've got to file a notice of intent. And so suppose in paragraph 5 of a medical malpractice complaint there is an allegation of all conditions precedent have been met, and met by virtue of filing a notice of intent. So would it be proper in that case for that defense attorney to append that notice of intent and say, well, no, that was not the claim in the notice of intent, and Judge, you need to throw this out because that's not what the hospital, doctor, care provider was on notice of?
Yeah, I cannot speak to medical malpractice claims because I don't practice in that area. I know it is statutorily driven, just like the EEOC Title VII claims
it
are
is the
statutorily
condition
driven.
precedent. I mean, I will represent. You can't bring the claim unless you have gone through the pre-suit process, including a notice of intent.
And here, I think we're going to get caught up in semantics on the term condition precedent. Because if you look at the cases that cited in both briefs, you will see that the courts, whether it's a district judge court or the 11th Circuit or other appellate courts, will use different terms in defining what the charge represents. But what they are consistent on is that what's contained in the charge or reasonably could grow out of the charge is what drives the allegations in the subsequent complaint. And here the problem with the charge, it's very clear, and it's not that they failed to check off the boxes and therefore they didn't exhaust the remedy. What you look at is they didn't check the boxes off, and they were represented by legal counsel when this charge was filed. You look at the particular section which comes below the boxes that you check on the charge, and that's what really drives whether the claimant has exhausted their remedies or not. And you look at the particular section, And in this particular case, you look at the laws that they cite to. They cite to Title VII in the Florida Civil Rights Act, and they bring in a marriage/associational discrimination claim. I suggest to you the associational discrimination claim was brought, and none of the other boxes were checked, or none of the other discriminatory categories were referenced, or any of the other statutes, the Americans with Disability Act or the Age Discrimination and Employment Act, were not mentioned in the text of the charge. The reason being is because under federal law, marital status is not a protected classification. So in order to fashion what you could allege under the Florida Civil Rights Act, because that's a protected category under the Florida Civil Rights Act, marital status, you try to bring an associational claim in some fashion under Title VII, which in effect is a mask of the marital status claim. And you look at, and you can see this in the text of the charge.
Let me stop you there, if I may. And as I asked counsel during her argument, what do you do with the reference to the husband and his charge?
Absolutely nothing. What that is, and look at
It's there. You agree?
Oh, I understand it's there, and it's there for a reason. And if you read the language of the particular section, what do they say? They say that she was basically treated differently, disparate treatment, because of her marriage and association to her husband. It stops there. They reference the charge. What that is your classic Me Too. The same thing happened to him that happened to me, therefore I'm the victim of discrimination. It doesn't add to the associational claim. What they confuse also is the difference between an associational claim and a retaliation claim. So what they say is Ms. Summerlin was discriminated against because of her husband's age, gender, disability, and then they bring the retaliation claim. An association claim is not a retaliation claim. If you look at the Thompson decision, which is the U.S. Supreme Court case that I think both of us cite to.
I read that, but why would they not be allowed to bring in his charge as part of the analysis by the trial court by virtue of the reference in the charge that you've appended that you say is a necessary part of the analysis? Why wouldn't his charge be part of the analysis?
Because it does not add anything to her charge. Look at it, just says the same thing happened to him that happened to her, and he also, like her, filed a charge of discrimination. That's what the particular section says. That's why I say it's not relevant.
Well,
it would not
couldn't
have
that potentially add some I don't know what his charge said. It's not in our record. But suppose under the ADA, I think there was some reference to the ADA earlier, he references an ADA claim. Could that not create an associational tether to the plaintiff in our case by virtue of what he may have said in that charge?
Depending on what he said in the
It
charge.
could.
If he just said, I had a disability, no. You have to put more into it than that. And there was the question about his disability. Where that claim...
Suppose in the charge they have health insurance concerns about me because of my disability, or they are concerned about me communicating it to my wife, and/or it is causing some disruption in the workplace that it shouldn't be causing. I mean, if he said that in the charge, that would be a good enough thing.
That is, if she put it in the charge that's what was occurring, yeah, those are your classic examples of associational discrimination.
But suppose he said it in
ADA.
his charge. That's my question.
Do what?
If he said it in his charge, would that not envelop her right to bring a claim for those same charges? I'm just asking.
I'm hesitating because I'm trying to understand. It depends on what he puts in his charge, but no, because if you look at the text of the particular section of her charge, she makes no association claim. She makes it by writing it in after the box other. That's like saying other, and you type in the word discrimination. The courts have consistently said that those conclusory allegations are not enough. referencing his charge saying, what happened to me happened to him, is not an associational discrimination allegation. So that reference to the charge is not, he made all these other claims, what happened to me happened to him. So what she's trying to do is bolster her allegation by referencing his charge. She's in no way tying any protected activity or status of his to what happened to her. And the reason why you can see that is if you look at the top of the particular section.
How do we know that, though, without looking at his charge?
Do what?
How do we know that without looking at his charge? What you just said.
Because you look at the text of her charge, you look at the particular sections and what she pled and how she pled it. One, it's a wrongful termination claim. You look at that, it's I think on the third line of the particular section where she refers to this being a wrongful termination claim. You look at the date of the charge, in the charge. In that box, you have a beginning date and an ending date. And you can check continuing if it was continuing. They put one single date, and that's the date of the termination on it. So that there's no connection to her husband's activity that charge would cause EEOC to investigate.
Well, what about the term association? Isn't that a connection?
I call it the same thing as the term discrimination. What does it mean? And the conundrum here is when you look at what they did at the Third Amendment complaint, they do association by what? Gender. They do it by an alleged disability. They do it by age. Whether that's valid or not, because the only statute that carries an associational discrimination clause is the ADA. Title VII and the ADA don't have those comparable provisions in it. But that's the problem, is then you get back to what is the purpose of the charge. And by merely saying association, how does that put EEOC or the defendant on notice of what type of association charge are you bringing? Because there's multiple types and multiple fact patterns as to what's going on. And that's why I go back to, for example, the cases that we listed in our supplemental memorandum at the trial level. You'll see that there's 4 cases, 2 involving the ADA, 2 involving the ADEA, where an ADA or the ADEA claims were made in the charge of discrimination. So they bring claims under those statutes in the complaint. But what got dismissed were the additional factual bases for the disability claim or the age claim brought in the complaints that were not brought in the charge. So, for example, you bring an ADA claim and it's in the charge, it's predicated on a termination. Then you file your lawsuit and you bring an ADA claim. You think maybe that's okay because you brought the ADA charge at the administrative level. But in your complaint, not only do you say the basis for the discrimination claim is the termination, but then you add a failure to accommodate claim, which is a separate claim under the ADA, or a retaliation claim for requesting an accommodation. And the cases we cite threw those out because they were not contained in the charge. What was contained in the charge was a termination or a failure to promote or failure to transfer, and there was no reference to the accommodation portion of the ADA. And the court said, you don't get to bring that in the complaint or in the civil lawsuit because you didn't raise it in the charge, even though you did raise a violation of the ADA in the charge. And that's kind of how I see the posture of this case. And I know I'm over. I didn't know if you wanted me to address the disability of the husband.
All right.
I'll be happy to do that.
Counsel, we appreciate your argument.
Okay. Thank you.
I'm going to add an extra minute, so you have 4 minutes.
I wanted to start towards the end of some of the things that counsel said. The first being the charge itself, and it's page 118 at the record. It indicates that the latest date that the discrimination took place, the date is under the sort of section that says latest. Admittedly, this is not the easiest form to work with sometimes, is April 21st, 2017. That's the date she and her husband were terminated. There's no additional claims coming after that time. It's not one of the many of the cases that they cited in their supplemental memorandum below, which appear in the answer brief, which counsel was just talking about, state that, for example, had Ms. Summerlin filed her charge of discrimination when she was experiencing an act of retaliation, then got fired and didn't go back and either amend her charge or file a new charge, that claim is not properly exhausted, because I think it's National Railroad is the case that sort of the initial case that states that that's a discrete action. You have to file a new charge of discrimination to exhaust. That's not the case here. We waited until after the termination, essentially, and filed the charge, and it relates back to every single thing that she describes in this charge of discrimination. And notably, which is that she checked the box for, admittedly, marital status is a particular to Florida law. It's not something that you can bring under federal law, which is why it's not in the complaint. But associational discrimination, that's the key here. She checks the box for other, writes associational discrimination, and in this charge, she says essentially that I was subjected to poor treatment because of the actions taken against my husband. And counsel stated repeatedly, this is classic Me Too, or what happened to him, what happened to me. That's kind of the point. He was targeted and terminated, and she was then targeted and terminated because she was married to him. The reason marital status and the fact that they are married is referenced in here is because that is their association. This isn't a close friend. This isn't a mother and son situation. This is husband and wife. Hence, we were married, and I was treated the same way because of his protected characteristics. Which is, again, why the reference to his charge is so important. She has told the EEOC, look, you need to investigate this. I was the victim of associational discrimination and retaliation, and I was terminated, and all these other actions were taken against me because of what happened to my husband. You're also investigating his charge. That's going to alert the EEOC that there are other things they need to look into. This is essentially a brief, very small statement to give the EEOC sort of the foundational markers of where its investigatory path is supposed to go. And we filed his charge. It's actually in the record at page 174. In response to counsel filing this charge as part of their motion to dismiss, we also filed their two position statements where they respond to Mr. and Mrs. Summerlin's charges of discrimination. The EEOC essentially investigated both of these. It had been on notice. We can assume that then all of the factual allegations in the complaint would be reasonably expected to grow out of this EEOC investigation, where we told the EEOC to go investigate this. My husband was also discriminated against, or was discriminated against and retaliated against, and that is the reason I got fired. Should we essentially just hand that over to the EEOC and say this is what the investigation is about, thus exhausting her administrative remedies. So that's issue the first, and I don't think we really got into any of the other issues about the sufficiency of the pleadings. But as to her husband's disability, I know they filed, I believe it was the Champion case earlier this week or late last week, which was about a COVID-related situation. Well, here in that particular complaint, there were no specific descriptions about what the plaintiff experienced as his medical issues. That's different here. And I think that that case actually illustrates the fact that we have alleged sufficiently that he experienced some kind of workplace issue that prevented him from being able to perform his duties fully. So if there are no further questions, I'm done.
Okay, thank you. Thank you to both counsel. The cases are submitted, and we are in recess.
Rise.
Like you.